Be ready? Let's start. Section 138 of the Act makes a civil transaction to be an offence by fiction of law, full stop, where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person is returned by the bank unpaid, either because of the amount of money standing to the credit of that person being insufficient to honor the check, or that it exceeds the amount arranged to be paid from the account, such person, subject to the other conditions, shall be deemed to have committed an offence under the said section, and be punished for a term, which may extend to 1 year, or with fine, which may extend to twice the amount of check, or with both, full stop, para. To make the dishonor of the check as an offence, the aggrieved party is required to present the check to the bank within a period of 6 months from the date on which it is drawn, or within the period of its validity, whichever is earlier, and the payee or the holder in due course of the check makes a demand for payment of the check amount by giving a notice in writing to the drawer of the check within 15 days of the receipt of information by him from the bank regarding the return of the check as unpaid, and drawer of the such check fails to make the payment of the amount within 15 days of the receipt of the said notice, full stop. Section 139 proceedings were pending against him at the time of appointment, full stop. The court rejected the plea taken by the employee that the form was printed in English and he did not have good knowledge of that, and therefore could not understand as what information was sought, full stop. The apex court held that as he did not furnish the information correctly at the time of filling up the form, the subsequent withdrawal of the criminal case registered against him, or the nature of offence were immaterial, full stop. The requirement of filling column numbers 12 and 13 of the attestation form was for the purpose of verification of the character and antecedents of the employee as on the date of filing in the attestation form, full stop. Suppression of material information and making a false statement has a clear bearing on the character and antecedent of the employee in relation to his continuance in service, full stop, para. The Honorable Apex Court further held that there has to be a deliberate and willful misrepresentation, and in case the applicant was not aware of his involvement in any criminal case or pendency of any criminal prosecution against him, it cannot be held that the made a misrepresentation, full stop. In this said case, the information sought was as to whether he has ever been arrested, as the applicant was wanted in a criminal case and he has got a stay order from the court, full stop. He furnished the information in negative, full stop. The Honorable Supreme Court held that it may be a case of mistaken impression but not a deliberate impression, full stop.